Namaste Shivusha. Welcome students to online session of Business Law, Part 25, Essential of a Contract of Guarantee and the Kinds of Revocation and its Effect. આપણે જોશું Contract of Guarantee નું. Essential of Contract of Guarantee. Very first is must be made with the agreement of all the parties. ત્રણ પાર્ટીના કન્સર્નથી એગ્રીમેન્ટ કરવાનું રહેશે. All the three parties to the contract, as per that, the debtor, creditor, right, and a surety must agree to make such a contract with an agreement of each other. Illustration: Sam lends money to Akash. Sam is the creditor, Akash is the principal debtor, and Sam approaches Raghav to act as a surety without any information to Akash. Raghav agrees this is not valid, right? Debtor, creditor અને surety ત્રણેયની વચ્ચે contract હોવો necessary છે, right? Consideration: according to section number 127 of the Act, anything is done or any promises made for the benefit of principal debtor is sufficient consideration to the surety for the given guarantee. The consideration must be a fresh consideration given by the creditors and not a past consideration. It is not necessary that the guarantor must receive any consideration, and sometimes even tolerance on the part of the creditor in case of default in also enough consideration. કન્સિડરેશનની વાત કરી સેક્શન નંબર 127, રાઈટ, કે ભાઈ અહીંયા ડેપ્ટર છે, રાઈટ, પૈસા ભરી નથી શકતો, દેન વિધાઉટ એની કન્સિડરેશન શ્યોરિટી છે અને ગેરંટી આપી છે એટલે એને શું કરવું પડશે? પે કરવી પડશે. કન્સિડરેશન છે એ ફ્રેશ કન્સિડરેશન રહેશે, રાઈટ. તમારા ક્રેડિટર્સ, રાઈટ, ઇન કેસ તમારો ડેપ્ટર ફૂલફિલ નથી કરી શકતો, તમારે ગેરંટીઓ તરીકે તમારે વર્ક કરવું પડે છે ઓર પ્રોમિસ ફૂલફિલ કરવું પડશે. નેક્સ્ટ, liability. In a contract of guarantee, the liability of a surety is secondary. This means that since the primary contract was between the creditor and principal debtor, liability to fulfill the returns of the contract lies preliminary with the principal debtors. It is only on the default of principal debtors that the surety is liable to repay, right? Surety છે અને repay કરવું પડે છે, right? એની liabilities છે એ secondary તરીકે વર્ક કરે છે. ડેપ્ટર ફૂલફિલ નથી કરી શકતો તો ડેપ્ટર્સની liability ફર્સ્ટ રહેશે preliminary, right? પછી surety રહે છે. Existence of debt. The main function of contract of guarantee is to secure payment of the debt taken by the principal debtor. If no such debt exists, then there is nothing left for the surety to sue. Hence, in case when the debtor is in time barred or void, no liability of surety arises. Existence of debt. Main function contract of guarantee is to secure the payment, right? Payment of debt. જે debtor પાસે ડેપ્ટરે લીધો છે, રાઈટ, એ પેમેન્ટની શ્યોરિટી એ મેઇન છે. એક્ઝિસ્ટન્સ ઓફ ધ ડેપ્ટ હોવો જરૂરી છે તો જ શ્યોરિટી થાય, રાઈટ. ડેપ્ટ ન હોય તો એક ટાઈપની શ્યોરિટી લેવી પડે નહીં, રાઈટ. એટલે એક્ઝિસ્ટન્સ ઓફ ડેપ્ટ ઇઝ નેસેસરી. નેક્સ્ટ, must contain all the essential of a valid contract. એટલે since a contract of guarantee is type of contract, All the essentials of a valid contract will apply in contract of guarantee as well as, right? Thus, all the essential requirement of valid contract such as free consent, valid consideration, offer, acceptance, intention to create legal relationship, etc. must require to fulfill, રાઈટ એટલે શું કે છે કે ભાઈ કોન્ટ્રાક્ટ ઓફ ગેરંટી એક ટાઈપનું કોન્ટ્રાક્ટ જ છે એટલે બધા એસેન્શિયલ એલિમેન્ટ્સ છે પણ એમાં ઇન્ક્લુડ થઈ જવા જોઈએ. નેક્સ્ટ છે નો concealment of fact. The creditor should disclose to the surety the fact that are likely to affect the surety's liability. The guarantee obtained by the concealment of such a fact is invalid. Thus, the guarantee is invalid if the creditor obtained it by the concealment of material fact. શું કહે છે ક્રેડિટર્સ છે એને શ્યોરિટીને બધી વસ્તુ ડિસ્ક્લોઝ કરવી પડે, રાઈટ? કે ભાઈ તમારી લાયબિલિટી છે એ પણ ડાયરેક્ટલી અફેક્ટ થાય છે એ બધી વસ્તુ મેન્શન કરવી પડે, રાઈટ? કે તમે ગેરંટીયર તરીકે વર્ક કરો છો. ઓકે, નેક્સ્ટ નો misrepresentation. The guarantee should not be obtained by misrepresenting the fact or the surety. Though the contract of guarantee is not a contract of Uberrima fide as per that of absolute good faith and thus does not require complete disclosure of the material fact by the principal, debtors or creditors to the surety before he enters into a contract, but the fact that are likely to affect the extent of surety's responsibility must be truly presented. Misrepresentation એક ટાઈપનું હોવું ન જોઈએ, right? Guarantee should be obtained without misrepresenting the fact of surety, right? Uberrima fides નો meaning થાય છે absolute or good faith. એટલે બધાય વસ્તુ ડિસ્ક્લોઝ કરવી, right, of all the material fact, debtors and creditors to surety, right, to enter into a contract. કારણ કે surety ની responsibility છે એ પણ affect કરે છે. Next, written, not necessary. Contract of guarantee might either be oral or written. It may be expressed or implied from the conduct of parties, right? એવું જરૂરી નથી કે આ કોન્ટ્રાક્ટ છે એ રિટન ફોર્મમાં જ હોય. નેક્સ્ટ, in case co-surety does not joins. Section number 144 કહે છે, for example, A agrees with B to stand as a security for C for a loan of rupees 1 lakh provided D also joins him a surety. D refuses to join. A is not liable as a surety. A agree કરે છે B ને to stand as surety for C, right? For a loan of rupees 1 lakh. 1 લાખ રૂપિયાની લોન માટે એ છે શ્યોરિટી તરીકે ઊભું રહેવા માટે તૈયાર થાય છે. Provided D also joins as surety. D પણ જોડે surety તરીકે વર્ક કરે તો, right? D શું કરે છે? રિફ્યુઝ કરે છે, ના પાડે છે, તો joint as surety. So A is not liable as a surety, right? Kinds of guarantee and its revocation. કોન્ટ્રાક્ટ ઓફ guarantee ના બે સ્પેશિયલ ટાઈપ્સના રીતે રિવોકેટ થાય છે. વેરી ફર્સ્ટ ઇઝ specific guarantee, or you can say simple. When a guarantee is given in respect to a single debt or a specific transaction and it to come to an end when the guarantee debt is paid or the promises is duly performed is called a specific or simple guarantee. However, guarantee which extended to a series of transactions is called a continuing guarantee. According to section number 129, the surety's liability in this case and would continue till the transactions are proved, are compelled, or till the guarantee revokes the as to the future transaction. Right? Specific simple guarantee can assure a specific time period. The સુધી guaranteer તરીકે વર્ક કરે છે, right? કન્ટિન્યુઅસ છે એ શું છે કે એ ગેરંટીયર વર્ક કરે છે પણ એક્સટેન્ડ કરે છે ટુ ધ સિરીઝ, રાઈટ? સિરીઝ ઓફ ટ્રાન્ઝેક્શન સુધી એક્સટેન્ડ કરે છે, રાઈટ? શ્યોરિટીઝ લાયબિલિટી શું થાય છે? કન્ટિન્યુ કરે છે ટિલ ધ ટ્રાન્ઝેક્શન ઇઝ કમ્પ્લીટેડ, રાઈટ? કાં તો ગેરંટીયર છે એ વર્ક કરે છે ત્યારે. નેક્સ્ટ illustration છે. S is a bookseller who supplies a set of books to P under the contract that if P does not pay for the books, his friend K would pay the payment. This is a contract of specific guarantee and K's liability would become to an end the moment the price of book is paid to S. S છે bookseller છે, સપ્લાય કરે છે બુક્સ પીને. પી અગર પે ન કરે તો કે પે કરવાનું છે, રાઈટ? કેની લાયબિલિટી ક્યાં સુધી છે? તો જ્યાં સુધી પી છે એસને પૈસા ન આપી દઈએ બુક્સના ત્યાં સુધી. જેમ પૈસા આપી દઈએ એમ એમ છે guarantor, right? K would come to an end the moment the price is paid to bookseller S, right? Continuing guarantee. A continuing guarantee is defined under Section 129 of the Indian Contract Act 1872. A continuous guarantee is a type of guarantee which applies to the series of transactions. Right? હમણાં આપણે જોયું હતું આગળ જ. It applied to all the transactions. The principal debtor also came to an end. Therefore, the banker always preferred to have a continuous guarantee so the guarantor's liability is not limited to the original advances and would not extend to all subsequent dates. Right? આગળ પણ ટાઈપ થઈ ગયું હતું, સેમ વસ્તુ રિપીટ થાય છે. Important features of continuing guarantees here is that it applies to a series of separate distinct transactions. Therefore, when a guarantee is given for an entire consideration, it cannot be termed as a continuing guarantee. Illustration. K gave his house to S on a lease for the 10 years on a specific lease rent. P guarantees that S would fulfill his obligation after even the years S stopped paying the lease rent. K sued him for the payment of rent. P then gave a notice revoking his guarantee for the remaining 3 years. P would not be able to revoke the guarantee because the lease for the 10 years is an entire indivisible consideration and cannot be classified as a series of transactions and has not a continuing guarantee, right? Simple illustration. હવે revocation of guarantee. Revocation of guarantee છે એ પહેલું છે by notice, section number 130. A continuous guarantee may at any time be revoked by the surety as to future transaction by given a district notice to the creditors. For example, A is A in consideration of B's discounting at A's request, bill of exchange for C guarantees to B for 12 months the due payment of all such bills to the extent of 5,000 rupees. B. Discount bills for C to extent of rupees 2,000 rupees. Afterwards, at the end of 3 months, A revokes the guarantee. This revocation discharge A from all liabilities to B for any subsequent discount, but A is liable to B for the 3,000 rupees on the default of C. Right? Education section number 130 is for the notice guaranteed at any time, right? May revoke the surety as the future transaction. Next, by that 131, the death of surety will operate as a revocation of the continuing guarantee, which regards to further transaction unless the contract provides otherwise. No notice of death needed given to the creditors here. Hire of the surety will not be liable for any fresh transaction entered into by the creditors with a principal debtors after the death of surety without the knowledge of such death, right? આવી રીતના બે રીતે તમે રિવોક કરી શકો છો. થેન્ક યુ. હેવ અ નાઇસ ટાઈમ.